And we'll call our meeting to order. Good morning, everyone.
Good morning.
Welcome, Ellen.
Good morning. I'm Czajkowski, Office of Legislative Counsel. I think we're starting with the board. Great. Before you and on paper and on the screen is an excerpt from what will be the next draft of your bill, containing the sections related to the structure of your new board, which we based on sort of the hybrid 2 structure that you discussed a few days ago. So I think I'm going to just walk you through the language, and then you can help me make sure that I captured all of the pieces. I think there are a couple of details we need to discuss about the specific, who specifically has powers with this board. I worked on this language I wrote this language on Sunday, and the only person who has seen it is Matt Chapman. He weighed in on some of the, a couple of things, but really this is what I gathered from our conversation on Friday and Thursday. So, all right. So, section 6021, board, vacancy, removal. A natural resources board is created. The board shall consist of 3 members, nominated, appointed, and confirmed in the manner of a superior judge, so that each appointment expires in a different year. The board shall be full-time employee. The board members shall be full-time employees. In making these appointments, candidates shall be sought who have experience, expertise, or skills relating to environmental science, natural resources law and policy, land use planning, community development, environmental justice, or racial equity.
Where's the base of this language? Like the crossouts, is it the current board structure that this language is coming from?
Yep.
Thank you.
And a lot of the things in that paragraph are similar to what we've been working with for the last couple of iterations. I changed line 5 through 7 a little bit so that your years it's 3 people with 6-year terms, so I had to tweak that sentence a little bit so that each appointment expires in a different year. But the qualifications down on lines 10 through 12, that's language you've had for a while.
When you say a while, like from the verb?
Yeah. So down on line 13, the appointing authority shall ensure, to the extent possible, that the board membership reflects the racial, ethnic, gender, and geographic diversity of the state. Following initial appointments, the members shall be appointed for terms of 6 years.
Ours was the verb was 4.
Yep. Yeah. So this is a slight change from that.
Current board members is 4.
Yes. Yep. Yeah. So what you're looking at is existing statute. I'm not amending the language of your bill. I'm amending the language of the statute. So this is how it will appear in your bill. Yep. On to page 2, line 5. The chair of the board may assign district commissioners to sit on specific matters before the board in situations where fewer than 5 members are available to serve.
5.
Right, so remember we had the conversation last week about what happens when people are disqualified? We can assign district commissioners. And part of that is because originally the language above that on page 2, we don't have alternates for the board.
Right.
So
I wonder about
That is something to consider. I don't think the PUC has alternates, so that language is struck. So you have 3, okay, alright, so take a step back further. So the board that we're contemplating here is the 3 full-time members. When I get into the discussion about the permits, when permits are issued, I refer to the board, and those are the 3 members, as well as the district commissioners from the region. So that is an important distinction because the board also has power to do rulemaking and hear appeals of the state, the state designation. And so the district commissioners will only be part of the group on major permit applications.
And not on appeals.
Appeals go to the Supreme Court. But
Wait, doesn't the district coordinator, jurisdictional opinion, doesn't that appeal to the board?
that is appeal to the board.
That doesn't go to the Supreme Court until the board hears it, right?
Yep, so that's another one, so that will not have district commissioners on it, just the board. That's a policy decision too, if you'd like to, change that, but as I was hearing the discussion last week, you have 5 members when you're making a permit decision. The other powers of the board are with 3, the 3 permanent members.
You heard it right.
Okay. Line 9.
Yeah, so just clarify a question. So what are those other powers? What would they be covering that would only entail 3? Just for my own.
We're gonna get to them.
We'll get to them, if we get to them.
Okay.
Yeah, they're, yeah.
Okay, fine.
We'll get to them. So, line 9 on page 2, terms, vacancy, succession. The term of each appointment, subsequent to the initial appointments described in A, shall be for 4 years. That's a mistake. Any appointment to fill a vacancy shall be for the unexpired portion of the term vacated. A member wishing to succeed himself or herself in office may seek reappointment under the terms of this section. Removal. Notwithstanding the provisions of 3 VSA 2004, the chair and members shall be removable for cause only. Page 3, retirement from office. When a board member who hears all or substantial part of a case retires from office before the case is completed, he or she shall remain a member of the board for purposes of concluding and deciding that case and signing the findings and judgments involved. A retiring chair shall also remain a member for the purpose of certifying questions of law if a party appeals to the Supreme Court. So that language was part of this is existing from the prior structure. So next, here's another policy that we need to make sure that I captured correctly. So this is the section about personnel and hiring personnel. We had talked about whether or not the board should have direct control over, as part of our other discussions, who has control over the district commissions and the district coordinator and the personnel they hire. So as I walk through this, we can make sure that I captured accurately what you would like the personnel structure to be. So regular personnel, the board may retain legal counsel, scientists, engineers, experts, investigators, temporary employees, and administrative personnel as it finds necessary in carrying out its duties, and may authorize the district commissions to retain personnel to assist on matters within its jurisdiction, including oversight and monitoring of permit compliance. Personnel employed by the district commissions pursuant to this subsection shall not report to the board. So that language had been part of our previous discussions, and I don't know if you still wanted that specific language in there.
I think let's keep track of our questions and let's do the walkthrough so that we can understand the whole picture and then come back and ask our questions.
Personnel for particular proceedings. The board may authorize or retain legal counsel, official stenographers, expert witnesses, advisors, temporary employees, and other research services to assist the board in any proceeding before it under this chapter. Bless you. And to monitor compliance with any formal opinion of the board or district commission. The personnel authorized by this section shall be in addition to the regular personnel of the board. The board shall fix the amount of compensation expenses to be paid to such additional personnel. District commissioners. For the purposes of administration of this chapter, the state is divided into 9 districts. So we didn't change the makeup of the district commissions or the regions. A district environmental commission is created for each district. Each district commission shall consist of 3 members from the district appointed in the month of February by the governor, so that if 2 appointments expire in each odd numbered year. So this is the existing structure, we're just adding to it slightly. 2 of the members shall be appointed for a term of 4 years, and the chair of each district shall be appointed for a 2-year term. In any district, the governor may appoint not more than 4 alternate members from the district whose term shall not exceed 2 years, who may hear any case when a regular member is disqualified or otherwise unable to serve. The governor shall ensure to the extent possible that appointments are made in a timely manner, and that each district commission includes the racial, ethnic, gender, and geographic diversity of the state. So, I added the phrase in there in a timely manner. That was part of the discussion last week. So that, otherwise that language about diversity was part of our earlier discussions weeks ago. But last week there was the discussion about how regularly or how timely they are made.
Is there later.
Page 5. Members shall be removable for cause only, except the chair, who shall serve at the pleasure of the governor. Any vacancy shall be filled by the governor for the unexpired period of the term. The chair of the board may appoint and assign district commissioners to sit on specific cases when some or all of the regular members and alternates of the board are disqualified or are unable to serve. Powers. Okay. So the board and district commission shall have supervisory authority. This is language that has existed for a while. Supervisory authority in environmental matters respecting projects within their jurisdiction, and shall apply their independent judgment in determining facts and interpreting law. They shall each have the power, with respect to any matter in its jurisdiction, to administer oaths, take depositions, subpoena and compel the attendance of witnesses, and require production of evidence. Allow parties to enter upon lands of other parties for the purposes of inspecting and investigating conditions related to a matter before the board or commission. Enter upon lands for the purpose of conducting inspections, investigations, examinations, tests, and site evaluations, as it deems necessary to verify information presented in any matter within its jurisdiction, and apply for and receive grants from the federal government and from other sources. So those are existing powers, but that you should hear all that language. Mm-hmm. The powers granted under this chapter are in addition to any other powers that may be granted by other legislation. The Natural Resources Board may designate and establish such regional offices as it deems necessary to implement the provisions of this chapter and the rules adopted hereunder. The Natural Resources Board may designate or require a regional planning commission to receive applications, provide administrative assistance, perform investigations, and make recommendations. At the request of a district commission, if the board chair determines that the workload in the requesting district is likely to result in unreasonable delays, or that the requesting district commission is disqualified to hear a case, the chair may authorize the district commission of another district to sit in the requesting district to consider one or more applications. The Natural Resources Board may by rule allow joint hearings to be conducted with specific state agencies or specified municipalities. The board may publish or contract to publish annotations and indices of the decisions of the Environmental Division and the text of those decisions. The published product shall be available at a reasonable rate to the general public and at a reduced rate to libraries and governmental bodies within the state. The Natural Resources Board shall manage the process by which land use permits are issued under Section 6086 of this title. May initiate enforcement on related matters under the provisions of Chapters 201 and 211 of this title, and may petition the Environmental Division for revocation of land use permits under this chapter. Okay, so that's one thing that I don't remember that we discussed at all. How do you want revocation of permits to work? Who should have the power to revoke a permit? Currently, the board petitions the Environmental Division to revoke a permit. Do you want the board to have that power now?
That's a little weird if they're issuing the permit. Wouldn't it be unusual? I mean, a permit gets revoked for non-compliance, so,
So just so the committee, so Matt Chapman, General Counsel, Agency of Natural Resources. For context, in most state agencies, the way revocations proceed is you provide the applicant with notice that the permit is going to be revoked. The applicant then has the opportunity, or the permittee then has the opportunity to request a hearing on that revocation. If they fail to request it, the revocation becomes effective without a hearing. If they do request a hearing, then we appoint it, in like A&R, we would appoint a hearing officer to conduct a contested case to allow them to present evidence on why the revocation shouldn't move forward. So in other words, it's all handled in-house.
the hearing is where?
At the Agency of Natural Resources. So either I or another attorney would be appointed a hearing officer, provided that we hadn't had any direct contact with the underlying revocation, the sort of fact-finding, and then we would conduct an evidentiary hearing to allow people to put evidence into the record to say why the permit should not be revoked, and then render a decision and present that to the secretary for her acceptance or denial.
And then where does that get appealed?
Because of the way A&R works, A&R permits would get appealed, or this process would go to the Environmental Division. If you were in another agency, it would go to the Supreme Court.
And right now at the NRB, it goes to, what happens?
It's a direct, go ahead if you want to, it's a direct matter to the Environmental Division.
Right, so just for some context, Evan Meenan from the Natural Resources Board, my recollection is when it was the old Environmental Board, when it was hearing appeals of permit decisions, it had the authority to revoke the permits. Right now, the board has the authority to petition the environmental court to revoke the permits, and the environmental court's decisions are appealable to the Vermont Supreme Court. I think that the board would like to retain authority over revoking permits if this hybrid model is adopted, and then those appeals would go to the Vermont Supreme Court.
Jim?
I like that Evan said, and that I would further suggest that it models the Agency of Natural Resources revocation of permits. It models the old NRB's practice, and I'm aware that our state agencies actually offer permittees time to correct their problems. They give them notice, dude, you're in trouble here, and you got to fix this. And when that doesn't happen, then then the hammer comes down, likely, if we're not talking about the Agency of Agriculture. So I don't see a problem with the board revoking permits that they gave.
Let's keep going.
Do we need to put that in or no?
Oh,
Yeah, you want me to change it? Okay. Do you want me to read through the grounds for revocation of a permit?
sure.
Okay. Grounds for revocation are non-compliance with this chapter, rules adopted under this chapter, or an order that is issued that relates to this chapter, non-compliance with any permit or permit condition, failure to disclose all relevant and material facts in the application or during the permitting process, misrepresentation of any relevant or material fact at any time, failure to pay a penalty or other sums owed pursuant to, or other failure to comply with, court order, stipulation agreement, schedule of compliance, or other order issued under Vermont statutes and related to the permit, or failure to provide certification of construction costs as required under subsection 6083AA of this title, or failure to pay supplemental fees as required under that section. Page 8. The Natural Resources Board may hear appeals of fee refund requests under 6083A of this title. So, do you want to maintain that? I wasn't sure the other day based on our conversation.
Which conversation?
When we were discussing generally the structure of the board. The chair, subject to the direction of the board, shall have general charge of the offices and employees of the board and the offices and employees of the district commissions. We've repealed that the board is a party before the environmental division. Alright, so here is another slight flag. This is new language. The board may delegate to district coordinators authority to determine whether an application is for a major or minor permit, to issue minor permit amendments, and administrative amendments, and the board may delegate to district commissioners or district coordinators any additional authority necessary for the effective administration of this chapter. So this language was part of the joint proposals board, and it was about the conversation of how the process is established. Do you want the board to have the ability to delegate power to the district coordinators, or should that be purely to the district commissions? Yeah.
I had thought we had talked about having the district coordinators with that authority on determining major and minor, that they're not getting granted that authority by the board, they have that authority. Does that make sense?
That was one of the options we talked about. Yeah,
Well, don't they already, they have that authority now, yeah.
they do.
But here we have the board may delegate, what if the board, it seems like we're setting us up for a conflict there, where I had thought we were, part of the function of the district coordinators was to determine the major and minor.
Can we hear how it's done today?
Today, it's the commissions that have the authority to decide if something is a major, a minor, or an administrative amendment. They have that authority because they are the ones issuing the permits. Coordinators review the application initially and offer recommendations to the commissions. The commissions can also get legal advice from the attorneys, but it is the commissions that make the decision. So the board, the board chair, Diane Snelling, has expressed that she likes this language, permissive delegation rather than a mandatory delegation.
With the substitution of commissioners versus coordinators.
No, the idea would be Well, that's a policy consideration, but it's the board that would
Okay,
like
yeah, okay.
the opportunity to delegate, have the delegation ebb and flow as necessary. I think the example that I gave the other day was, let's say you have a fresh-faced coordinator who needs some training before they start making these determinations. The board might want to keep a tighter rein on those folks while letting more experienced coordinators make these determinations rather than recommendations. That type of administrative flexibility.
I guess I thought we talked about the commissioners doing these duties. The JO stays with the district coordinator, but that the commissioners are making the rest of these, obviously in conjunction with support from staff.
Doesn't appear to be a broken task under the existing structure.
Right. And Jim,
We had talked about that, and part of the angst of this system is based on all the majors going to the board, and having all major projects decided outside of our communities, if you will. Notwithstanding, we've gotten language, well, we'll do it in your library or wherever. But that's not quite the same thing. This appears, and I think this was the other discussion, that the board gets to choose if it's going to be a major or a minor. And so this is a policy decision that we need to explore after we get through the walkthrough, I think.
although, to help, just remind us, Evan, how does, like a minor, the difference between a minor and a major has to do with the requested hearing. But if the commission is deciding, so someone comes to the commission, requests a hearing, and then they decide if they're gonna grant the hearing, then it becomes a major. Are there other criteria that?
No, I mean, that's basically it. I mean, the major difference between a major and a minor is whether or not a hearing is gonna be held. We had previously discussed that there's some other impacts relative to appeals, but it is whether or not a hearing is gonna be held. So, you know, if a commission did not feel like being a particularly active commission and they had the authority to designate something as a major, they could just start kicking all their cases up to majors for the board, and the board would have no authority. You know, if this were changed, the board wouldn't have any authority to say, we disagree. We don't think this needs to have a hearing. Commission, go back and do your work. You're fully capable of it.
That's the flip side.
And if you are a major, are you automatically a contested? Are those the same terms?
Well, I mean, if it's a major, that means you're going to have a hearing. And if there is a hearing, that means that everyone who has party status has an opportunity to present evidence and contest the evidence presented by other people. That said, there has frequently been hearings held where there really isn't much of a contest. It's just because the commission itself had concerns and questions that were best suited to be addressed in the hearing context. So it really isn't contested in the typical sense of the word, but there is a hearing.
Are party statuses awarded in a minor?
Yes.
And so now they're awarded before any decision is made as to whether to go for, whether it's going to be a major or a minor project. And I guess, let me just expand a little bit on that. I'm wondering if there's a project going on that I, for some reason, a citizen doesn't like, and wants to, weigh in with his opinion. At what point does he do that? Does he do it? Does he wait until the board makes the commission or the board makes the decision, or not?
It could end up happening that way, absolutely. So what could end up happening is the commission gets an application. They don't happen to see any big issues with it, so they say, let's process this thing as a minor. And they prepare a draft permit, they post it on the website, and then a neighbor or maybe a state agency or anyone else spots an issue that the commission didn't spot. And at that point in time, they could say, we have information that you think we should take into consideration. We would like to be a party. And then if they want to, they can also say, in addition, we think that a hearing should be required and this should be treated as a major. And at that point, the commission would revisit whether or not something should be a major or a minor, and that does not happen infrequently. People are familiar with that process and they seem to be able to navigate it well.
We have taken testimony that requests for hearings are, sometimes people are uncomfortable requesting hearings. And I'm wondering if the system's gonna make that even harder for people, because it's gonna trigger this another different type of review. Keep going.
Okay. Do you want me to make a change on line 10? Or are we gonna leave it as district coordinators?
Back to it. I think this group agrees that it's commissioners.
Okay.
If anyone disagrees, no.
Section 6084, notice of application, pre-application process, hearings, commencement of review. So this is the new language about the pre-application process. So the plans for the construction of any development or subdivision, subject to the permitting requirements of this chapter, must be submitted by the applicant to the district commission, municipal and regional planning commissions, affected state agencies, and adjoining landowners no less than 30 days prior to filing an application for this chapter, unless the municipal and regional planning commissions and affected state agencies waive such requirement. The district commission may hold a meeting on the proposed plans, and the municipal or regional planning commission may take one or more of the following actions. So I changed that a few days ago because originally it was going to be the regional planning commission or the regional or municipal planning commission holding the hearing, but you asked for it to be the district commission. So the planning commissions can take one or more of the following actions: make recommendations to the applicant within 30 days. Once the application is filed with the district commission, make recommendations to the district commission by the deadline established in the applicable provision of this section, board rule, or scheduling order issued by the district commission. The application shall address the substantive written comments and recommendations made by the planning commissions related to the criteria of subsection 6086A of this title received by the applicant, and the substantive oral comments related to those criteria made at a public hearing under subdivision 1 of this section. This subsection shall not apply to a project that has been designated as using simplified procedures pursuant to 25B1 or an administrative amendment.
Yeah,
Should we still have the provision about the, what we call scoping, meaning that before any kind of formal application is submitted, that basically the developer or the applicant gets together with the town and they take a look at what they're doing, and there's some kind of sense of whether or not they get kind of a weather report, whether this poses a problem or not. Are we doing that as things stand now?
I think that's what this language is getting at.
Okay.
Yep.
Read on.
Page 10. Upon the filing of an application with the district commission shall send by electronic means notice of the application to the owner of the land. If the applicant is not the owner, the municipality in which the land is located, the municipal and regional planning commissions for the municipality in which the land is located, A&R, and any adjacent Vermont municipality and municipal and regional planning commission if the land is located on a municipal or regional boundary. The district commission shall send by electronic means a copy of the notice to the town clerk's office of the town or towns in which the project lies. The town clerk shall post the notice in the town office. The applicant shall provide a list of adjoining landowners to the district commission. Upon request and for good cause, the District Commission may authorize the applicant to provide a partial list of adjoining landowners in accordance with board rules. Upon an application being ruled complete, the District Commission shall determine whether to process the application as a major application with a required public hearing, or process the application as a minor application with the potential for a public hearing in accordance with board rules. Page 11. For major applications, the board shall provide notice not less than 10 days prior to any scheduled hearing or pre-hearing conference to the applicant, the owner of the land if the applicant is not the owner, the municipality in which the land is located, the municipal and regional planning commissions for the municipality in which the land is located, any adjacent Vermont municipality and municipal and regional planning commission if the land is located on a municipal or regional boundary, adjoining landowners as deemed appropriate by the board pursuant to the rules of the board, and any other person the board deems appropriate. Anyone required to receive notice of commencement of minor application review pursuant to subsection C of the section may request that an application be treated as a major by filing a request with within the public comment period specified in the notice pursuant to board rules. The board, on its own motion, may order that an application be treated as a major within 20 days of notice of commencement of a minor application review. Any hearing or pre-hearing conference for a major application shall be held within 40 days of receipt of a complete application, and within 20 days of the end of the public comment period specified in the notice of minor application review, if the District Commission determines that it is appropriate to treat the application as a major application. Any hearing required shall be held in the municipality where the project is located unless the parties agree to an alternate location. When conducting hearings and pre-hearing conferences, the board shall exercise reasonable flexibility with its rules of procedure and of evidence to maximize pro se participation while ensuring the fairness of the proceeding. Any notice required by this section shall also be published by the District Commission in a local newspaper generally circulating in the area where the development or subdivision is located, and on the board's website, not more than 10 days after receipt of a complete application. This subsection concerns an application for a new permit amendment to change the conditions of an existing permit or existing permit amendment in order to authorize construction of a priority housing project. That's just because I changed the letter there. When an application concerns the construction of improvements for one or more of the following, the application shall be processed as a minor application. So I left those parts out because they hadn't changed. But
Wait, I'm confused about what's between G and H. Why are there stars there? Doesn't that usually mean something?
yeah, I left it out. I didn't make any amendments to it, so I didn't include it. But it's going to be it's the existing law.
So G has subsections or something?
Yeah.
Okay.
Yeah. Okay, page 13. Permit hearing. So this is a whole new section. When an application is deemed to be for a major permit, the board shall convene a hearing in the municipality where the project is located. The board and 2 members of the District Commission from the district where the project is located shall hear the parties to the application and decide the findings of fact and questions of law. The board and 2 district commissioners shall issue a decision on the permit. Upon appeal to the Supreme Court, its findings of fact shall be accepted unless clearly erroneous. The board shall allow all members of the public to attend each of its hearings unless the hearing is for the sole purpose of considering information to be treated as confidential pursuant to a protective order duly adopted by the board. The board shall make all reasonable efforts to ensure that the location of each hearing is sufficient to accommodate all members of the public seeking to attend. The board shall ensure that the public may safely attend the hearing, including obtaining such resources as may be necessary to fulfill this obligation. Hearing officers, page 14. 1 board member or any officer or employee of the board duly appointed by the chair of the board may inquire into and examine any matter within the jurisdiction of the board. A hearing officer may hold a hearing on any matter within the jurisdiction of the board. Hearings conducted by a hearing officer shall be in accordance with the contested hearing provisions of the APA. A hearing officer may administer oaths and exercise the powers of the board necessary to hear and determine a matter for which the officer was appointed. A hearing officer shall report his or her findings of fact in writing to the board in the form of a proposal for decision. A copy shall be served upon the parties pursuant to 3 VSA 811. However, judgment on those findings shall be rendered only by a majority of the board and the district commissioners. Completion of case. A case shall be deemed completed when the board and district commissioners enter a final decision, even though that decision is appealed to the Supreme Court and remanded by that court. Court of record, jurisdiction. The board shall have the powers of a court of record in the determination and adjudication of all matters within its jurisdiction. It may initiate proceedings on any matter within its jurisdiction. It may render judgments and enforce the same by any suitable process issuable by courts in this state. An order issued by the board on any matter within its jurisdiction shall have the effect of a judicial order. The board's jurisdiction shall include the issuance of any declaratory rulings on the applicability of this chapter and rules or orders issued under this chapter pursuant to 3 VSA 808, and the issuance of decisions on appeals pursuant to section 6089 of this title, which I'm about to read to you. Alright, appeals. Appeals of certain actions to the Natural Resources Board. Applicability. The following acts or decisions are appealable de novo to the board. A jurisdictional opinion issued by a district coordinator. A determination that an application is a minor application or an administrative amendment by a district commission. Page 16. A determination by a regional planning commission as to the sufficiency of the municipal bylaws pursuant to, this is the interchange language, 6001 3A 13, so that's the interchange. A determination by the Downtown Development Board designating a downtown development district or neighborhood development district pursuant to VSA Chapter 76A. That should be area. Okay.
I'll hold it.
Okay. Procedure. An appeal under this section A may be brought by any person aggrieved. As used in this subdivision, person aggrieved means a person who alleges an injury to a particularized interest protected by the provisions of law listed in this chapter, attributable to an act or decision by a district coordinator, district commission, downtown development board, regional planning commission, or the board that can be redressed by the board. A notice of appeal must be filed within 30 days of an act or decision. The board shall conduct all appeals under this section as contested cases pursuant to 3 VSA Chapter 25 using the procedural rules adopted by the board. Page 17. Appeals of decisions of the board. A party aggrieved by the final order, judgment, or decree of the board may appeal to the Supreme Court. However, the board, in its discretion and before final judgment, may permit an appeal to be taken by any party to the Supreme Court for determination of questions of law in such a manner as the Supreme Court may by rule provide for appeals before final judgment from a superior court. The same way someone would appeal from a superior court decision. Do you want to stop there before I move on? No? Okay. Okay. So this is also another new section, 6094, assessment of costs. This is the bill back language. The board may authorize itself or the Agency of Agriculture, Food and Markets, Agency of Commerce and Community Development, Agency of Natural Resources and its departments, or Agency of Transportation to retain legal counsel, official stenographers, expert witnesses, advisors, temporary employees, or other research, scientific, or engineering services, in addition to its regular personnel necessary for the review, processing, and adjudication of any permit application specific proceeding. With respect to the agencies, additional personnel may be retained only after approval of the governor and after notice to the applicant, including an estimate of the duration and costs of the personnel and services. The agency retaining the additional personnel shall fix the amount of compensation and expenses to be paid to the personnel retained under this subdivision. Page 18. Costs of additional personnel obtained under this subdivision may be allocated by the applicant to the applicant by the agency or the board. Notwithstanding any other provision of law, the Agency of Agriculture, Food and Markets, Agency of Commerce and Community Development, Agency of Natural Resources and its departments, or Agency of Transportation shall have the authority to bill the applicant for the costs of participating in any major proceeding before the board, including the cost of employee application review, submissions, comments, and testimony before the board. An agency may recover those costs from the applicant after notice to the applicant, including an estimate of the costs of the personnel or services. From time to time, the board or agency charging an applicant for personnel or services under this section shall provide the applicant with detailed statements showing the amount of money expended or contracted for in the work of such personnel and services. All funds collected from the applicants under this section shall be paid directly to the board, agency, or department. The board shall, upon petition of an applicant to which costs are allocated, review and determine after opportunity for hearing the reasonableness of such costs. The board shall consider the size and complexity of the project and may revise such cost allocations if determined unreasonable. Page 19. Nothing in this section shall confer authority on the board to select or hire personnel unless such personnel are retained by the board. Prior to allocating costs, the board shall make a determination of the purpose and use of the funds, identify the recipient of the funds, provide for allocation of costs to the applicant, indicate an estimated duration of the retention of personnel whose costs are being allocated, and estimate the total costs to be imposed. With the approval of the board, such estimates may be revised as necessary.
This is a basic one. What is 6A? Nothing?
So, the board can't hire A&R's experts. They can only hire their own experts. So they approve that other agencies can hire their outside personnel, but the board can't specifically pick them. Me? No, I'm good.
Say that again.
So, A&R or V-Trans is allowed to hire personnel, but the board can't hire those personnel for them. So just because they're approving the cost doesn't mean that they get to control the experts that that agency is going to use.
Okay. But if they're, in this sentence is saying they can hire their own.
Yep.
Just not for the other, I don't see the just not for the other agencies, but I guess
It's there.
it's implied.
You can't, they have the authority to approve the cost, but not to select or hire personnel unless, except for their own.
Right. Okay. All right. Comments? Committee? Questions?
On this latter part,
One A.
Yeah. Good question. But on this latter part, since this was in front of us right now, I'm still resonating the information we received in which the Department of Fish and Wildlife is contemplating reduction in the number of, in their participation in Act 250 because of lack of resources. And yet at the same time, we heard how critically important that expertise is, especially when we're addressing areas of critical concern, whether they're forest blocks or rare endangered species or deer yards. And so when we have the, are we finding ourselves between a rock and a hard place in terms of the inability of assuring the public that the appropriate experts will be participating, using their technical expertise to participate in proceedings in front of the board, including ANR expert witnesses with this language? Are we finding ourselves in a situation where the agency, because of lack of resources, could just say no to having their staff participate because of limited resources, in other words? And yet, that testimony would be critical in the determination of the outcome of the proceeding. That's kind of a.
So this language is allowing the agency to bill the applicant for their staff time. So I don't know.
Evan?
From the Natural Resources Board. So I think this is actually solving a problem rather than creating one. There is another statutory provision that's not being amended. It's 10 VSA 6024, and it actually obligates other state agencies to cooperate with the board in making its data, facilities, and personnel available as needed to the board for the board to accomplish its mission. But as a practical matter, ANR dedicates a lot of staff time towards participating in these Act 250 proceedings. And because they have the desire to do that, the board has never had to push them pursuant to this statute, which is a great thing. But if the financial burdens got too high on ANR, they might have to reprioritize their efforts and wait, and to avoid that, if there's a mechanism for reimbursing ANR staff time so that they can continue to participate at their desired level and the board's desired level, this actually solves that problem or helps solve it.
Thank you, that's very helpful.
Jim?
I'm thinking that as a matter of process, it would be good to now start at the beginning and work our way through with our questions, because answers to policy early on really inform questions further in. And so my first question, and then I certainly rest and let, I don't intend to go through the whole bill with my questions, is what I'm trying to say at this moment. So, on page 3, personnel, the board, and this comes to what the chair of the NRB likes, but I question if this is what we like. Line 11, the board may authorize the district commissions to retain personnel and assist on matters with within its jurisdiction, including oversight, monitoring, permit compliance. I think this is the part that the chair said she liked it. Actually, well, it's a little further on. Okay.
That's fair.
So, what happens, Ellen, if they don't, if the board doesn't authorize the district commissions? I mean, at their discretion, because this is May.
The board has general control over the district commissions, so the board does have discretion on that.
And so this is the old shall versus may. And what happens if they decide not to authorize the district commissions to retain personnel and assist on matters within jurisdiction?
So, it's interesting, the more we talk about this, so the district commission now, under this board structure, is really going to primarily be handling minor permits.
Mhm.
So, I don't know to what extent district commissions will need personnel for minor permits and administrative amendments.
I can only imagine that from time to time they need attorneys. They may from time to time need other additional assistance. We understand they need education. I'm not thinking the NRB will not do this, but when we say may, they have the option to not. If we say shall, then they shall help the district commissions on matters with blah, 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 blah.
Evan has something to add.
So I think that there could be several problems that could result if the word may is changed to shall, because it eliminates any discretion on the part of the board to control its own budget. So you could have a commission that says, okay, the board's giving us 4 attorneys, well, we don't like any of the advice that they've gotten us. The board can't prevent us from hiring our own person, so we're gonna go hire the most expensive attorney up in Burlington to provide us legal advice on this case at $300 an hour. Or we don't like what A&R's experts and the other party's experts are telling us, we're gonna go hire the most expensive wetlands consultant in New England at $350 an hour, and the board can't do anything about it. This is really the board doing some initial, do we have money in the budget to hire this person? Is this person actually gonna be qualified, and are they really gonna add much to the dialogue that's currently happening in the permitting proceeding? And if the decision is no, the board would say, commission, no, we're not gonna approve this expenditure of funds. We'll give you access to our attorneys. Maybe we'll give you permission to hire a less expensive expert or a more local expert, so we're not paying for plane tickets from California and so on and so such.
I object to your extreme examples.
Well, attorneys plan for the worst and hope for the best. Good attorneys do anyway.
But the core question is the one of control over the district commissions. And if they can't have the support because the board doesn't want to pay MSK's fee, thinks it's too high, and or I just say that because he's one of the premium terms. Committee's got my input on that. I think it should be shall, but I'm done.
I agree with Jim. I think it more or less reinforces how much power the board is going to exercise over the district commissions. To me, it seems to be the only power the district commission has now is when it sits with the board and gets to vote on an application. Outside of that, everything seems to be consolidated in the hands of the board. So I don't like that may authorize the district commission to retain personnel. Or I think the district commission should have the you know, the authority to determine whether it needs more help. I mean, they're basically looking for the best help they can get on a project, and I don't think they're gonna go all over New England to find some wetlands expert to do that either.
How often does a minor application require outside assistance?
Almost never. I mean, I can't we were talking about it the other day, and we could recollect one time that an outside expert was retained. But the concern is, you know, we have 9 district commissions. Imagine 9 district commissions each choosing to hire their own experts and their own attorneys to handle AAs and minors.
Isn't that a worst case scenario? I mean, it's, you know, does it happen much now? Is there that conflict going on presently?
No, but the question is whether or not you want the board to provide any oversight over the spending of the funds that it collects through Act 250 permit fees and through a general fund appropriation.
My question is, are the district commissioners running berserk over trying to find experts and then trying to pay them?
Currently, no, but you know, do we want to wait until we face that problem to come back and have another discussion about changing the law? Or do we want to provide for the flexibility now?
Well, it's just a question of where you put the power, isn't it?
Jim?
I said I was done, didn't I? But something that Evan said, this, because almost never now do district commissions require expert legal advice and blah, blah, blah. And that's rationale for keeping it at May, because the board is going to be handling majors. Well, we'll just figure that out in a little while, because I've got a mark on that one as well. I mean, we leave it where it is for the time being, but I still, I'd just as soon change it to shall, and if we need to change it back to may, we can do it back to
Shall.
Can I just, this language is trying to support the district commissions, and it's new language, except that, I mean, it's the authority right now is there, it's just this is expanding it to include other experts to support district commissions in their work.
So I wondered, as I listened to the committee's testimony, whether it might, rather than changing this to shall, put something, additional language in there that says, the board shall ensure that members of the district commission and the district coordinator have adequate or the resources necessary to perform their duties, including access to legal resources, training resources, and other, you know, other necessary resources. So that way you're ensuring that the board is providing staff resources to district commissions to allow them to function and excel in the job that they're doing, but not creating the budgetary issue that Evan is worried about.
I think that gets to why we have the language in there, to support district commissions. Carrie?
I just wanted to point out that we are integrating a pre-application meeting process, which requires facilitation skills to be able to wrestle through some of these issues at the district commission level. So I imagine we may be seeing a greater need for that kind of resources as we have been talking about. So I think we should be mindful of that. I think the suggested language might satisfy what we want to protect or ensure.
Well, we're increasing the criteria too. There's a lot more to consider now in how this is going to be structured. I mean, we're starting to talk about climate change. We've got fragmentation involved. I mean, there's a lot more decisions to be made before the thing even just starts to pick up speed and go on the record, it seems to me. And you're going to have some expertise. You're going to have to hire some expertise if you're a commissioner. You can't be expected to know all these things. Even before we decide whether it's a minor or a major. I don't know, I would keep may in at the very least.
I think I'm hearing we're keeping the language in, but we're gonna qualify it to explain the purpose.
I have something to add.
Okay.
I think, and I apologize because now I have taken language from like 3 or 4 sources. I actually think this may have originated as part of Jim Dumont's proposal to strengthen the district commissions. So it may not be that, take that as information about where this came from. I was just looking through the joint proposal to see how they addressed it, and I didn't find it initially, so I think this may have come from his proposal to strengthen district commissions, not contemplating the new board structure, so. But.
Thank you.
But I appreciate the chair's recommendation to think about qualification of that, just adds more information about the type of resources that we're talking about here that may be necessary at the district commission level. So I think both with Representative Faves and Representative Sheldon's comments, I think it makes sense to add that qualification.
Roger that.
You're right.
Wait, I missed it. Am I adding?
Yes, I think Counsel Chapman's comments, I think was helpful to kind of qualify.
I was digging. I was
Which
digging.
talked about the board shall ensure that appropriate resources are necessary to enable district commissions to function adequately, including, and I think you described it.
All right.
I have a question on page 4 and 5,
Sure.
unless anyone has a question before that.
Well, we did hear.
Yeah, I was gonna go back to page 1.
That's before that.
And, in terms of how the 3 members are nominated, I understand it's going to follow the same procedures as the Superior Court judge. My question was, is there a retention hearing after their period of service expires? I mean, after 6 years, is there now an attempt to challenge whether or not these guys, whoever's up for, wants to continue, whether or not people are, have problems with the way the ruling has gone, or whether he is ruled, or anything like that? Just another look, another public review of his performance in such an important role, if it's comparable to a Superior Court judge. I mean, how do you extend someone's term who wishes to go beyond 6 years?
There is language allowing for someone to seek reappointment. I don't specifically know about, I don't know the answer to your question.
So let's talk through the manner of a superior judge and then answer Paul's question about reappointment. Evan, can you address that?
Yeah, I can address that. So, Evan Meenan from the Natural Resources Board. So, the way that Superior Court judges are appointed is dictated by 4 VSA Chapter 15, which deals with the Judicial Nominating Board, sort of pre-screening the applicants, sending up a short list of qualified applicants to the governor's office, and then the governor's office appoints someone to be a judge, and then the legislature has to confirm that appointment. In terms of retention of Superior Court judges, that's handled by the Joint Committee on Judicial Retention, and there's a specific process that happens that's followed. It's not clear to me whether or not this proposal follows that Joint Committee on Judicial Retention, because the language on page 2, lines 13 and 14, indicates to me that instead of going through a retention process, the sitting board member would have to go through the original appointment and confirmation process all over again, which arguably is a slightly less efficient way to do it, and it is creating sort of a new process that Superior Court judges and PUC commissioners would not have to follow. They all go through the Joint Committee on Judicial Retention. I think they do. No, they
I
don't.
think they're appointed for a term of years.
For a term of years.
Yeah,
Okay.
that's
It used to be 6 years on
6
Sunday.
years.
And that's it. No
So
more.
that's the question. Do you want them to go through the retention process like a judge, or do you want them to just sort of go through the process again? And that's just a policy question.
So remind us who the Judicial Nominating Board is comprised of?
It has 11 members.
Who are,
2 members who are not attorneys. The governor selects 2 members that are not attorneys. The Senate selects 3 members. The House selects 3 members. And attorneys at law, I don't have this, I'm reading from the statute.
Must be the bar
The
association.
bar that has a
we have speeches on the floor from the members of the Judicial Retention Committee after they have done their due diligence to see if Judge Jim should be reappointed upon Judge Jim's wish to be reappointed. And they routinely exceed their amount of time in talking about what a great guy Judge Jim is. And then we vote on the retention. And so that, I think, is the process. They work really hard, the Senate and House Judicial Retention Committees, in making their recommends. And I think that may be what Paul's getting at. That the 3 members on the board going through that process, Paul?
Yes, I mean, I've heard or watched some very, robust discussions on whether or not a judge should be retained even after the committee has made its recommendation. I remember Duncan Kilmartin, for one person, who got very upset over one judge being retained, and it was able to enlist some support, so it was almost a half a day of hearing as to whether or not he went through, and it did. But I mean, I'm just saying, it was kind of a very, very public review. If there were any kind of really serious objections, and the reasons why they were being raised were aired fully. And so at the end of the discussion, you kind of had a sense of whether he was doing a good job or not. Yeah, and that's kind of what I would. I mean, I would like to see some sort of public review of the board members, especially if they're going to stick for 6 years. It seems like we should get us some sort of an accounting on how they perform.
Well, let's just say, do we think 6 years is appropriate? Ours had 4.
Where did the 6 come from?
The joint proposal.
It's probably similar, the Public Utility Commission is 6 years. And,
Long time.
and from my experience, formerly a hearing officer for the Public Utility Commission, I know one board member that was not appointed for political reasons, and that was a governor appointed. Well, not based on merit of performance, it was more based on politics. It happens when
Well,
you
if
have a
it's
governor
if it's a
appointed.
governor appointment, that's what
Appointment.
you're gonna have.
Sure.
What do folks think about the 4 versus 6 year terms?
I think in today's mobile society, 6 years is too long. I think 4 years are more appropriate today.
I was thinking 6 years would be better because you could keep more of a balance on that board. You'd have one governor appointing in year 1 and 6 years goes for a long time. 4 years, and you could have a reappointment of the entire board by one governor
I
who
think 6
wants a
years.
particular thing.
Well, they're staggered terms.
But still, if you're only waiting for the appointments come up more quickly.
Well, I think that speaks to your point, which is you're less likely to have one governor doing
Well,
I think.
I think the other way. I think the governor comes in, says, okay, I'm gonna appoint the head of the NRB. the new
For 6 years.
For, no, that's at the governor's discretion.
But it's still 6 years, isn't it? The chair's still a 6-year term,
All right.
but they just serve at the
So when that governor leaves that chair, right? That's what I thought.
well, let's clear that up. Is the chair a term under this draft?
Yeah, it's the same.
It's the same.
Yeah, we
Yep.
don't.
But, I mean, it's at the will of the governor, they could fire them, but,
Okay.
so if a new governor comes
So
in,
new governor comes in,
they can instate a new
they
chair.
put a new chair in, there's a 4-year term, it's
it's-
almost up for,
Sorry, they're removable for cause only. So
Oh,
they have
for
a term.
cause,
Yeah,
okay.
so it's
The
not.
chair also?
Yes,
Oh, I thought the chair.
I would,
but they're set terms unless they're for good cause only. Cause only.
All three have a set term, is that right? An
Yeah.
identical set term. It's gonna be staggered.
Yes. That's on page 2.
anyway, are you, all right, let me get to another question then. Are you able to serve for 6 years and then re-up for another 6 years?
Yep.
Yes.
Yeah.
So I think that going through some kind of retention hearing could be a good thing, because not only do you get reviewed, but you also have the chance to improve your performance under this new, I remember when we just did this last judicial retention hearing, somebody was having trouble during his term, but didn't find out till it was time to be reappointed. So the VBA said, well, we're going to have, of course, that's the VBA helping judges, this would be different. But there's nobody to help this person who's gone askew, because it isn't a judge. So we could, I guess, ask the bar to come in and help with it.
Yeah.
I agree with, so there's sort of two questions here, but on the 4 versus 6 years, I like 4 better, agree with Lee. And don't forget, even with what I support Paul in a judicial retention scenario, if it's 6 years, it suddenly becomes 12. and maybe 18. So 4 years, get a fair hearing in front of the joint judicial retention hearing, legislative retention hearing, and but the specific question I think was, is 4 years better? And I think 4 years is better.
And I have one more thing to say.
Well, I support Carol, I like 6 years, I think it's the way when you do have a retention hearing, you've got a kind of a measure of time as to how the individual performed. I don't know how many of these majors are gonna be heard within a 4-year period, I think there'd be more in a 6-year period, so
Yeah.
you'd have something more evidence to consider, and you know, your decision on whether he should be paid or not wouldn't be based on merit, it would be based on performance, it'd be more of a track record. You know, I got an election, and I've got 6 years that I'm thinking, what can I think about in 6 years that I did or didn't do, or did well or didn't do well. I just think that gives you a sense of kind of, I don't know, a better window into how a person is performing. Anyway.
I think I'm still in the 4.
Yeah.
I think 4 is more accountability.
The other thing I wanted to say about, and I don't know which way it goes, you can't make the argument, but what I'm thinking about is someone who knows they're going to be up for retention. The retention gets, if we do a retention process, that's super political. Then they're looking at how they decide things within that 4-year period. A regular judge in a court has so many things to decide, a superior court judge, even sitting in the environmental division. So there's a whole lot of input they get. But this particular person sitting in judgment has only input about Act 250 stuff. So now, what's the pressure on them? I don't know. I'm just saying. So what's the pressure on them? They've got 4 years or 6 years. Who do they have to account to so that when they come, they get renominated? Maybe they don't care about being renominated, but maybe they do.
After 6 years, they might not.
Yeah, but
All right.
starting to not like this process.
I would really like to talk through this, how this is gonna function, because I continue to have concerns about capacity. And I understand that having hearing officers be able to oversee the hearing in the district, that's probably gonna leave a hearing officer plus the 2 regional commission members at that hearing. And I just need to talk through with someone who's, how does that work? And I think 40 a year majors is the estimate, plus other duties that we've assigned to this board. And we're telling them, which I agree with, that the hearings will be in the regions, in the towns that these applications have been proposed for. Somebody needs to talk me through how that is gonna work. Because I just keep running up against capacity.
Figure it out.
What's that? You gotta figure it out.
No, I said we'll just have to figure it out. I mean, the best we can. I've been meaning from the board. I mean, we'll have to figure out how to put on this traveling roadshow with a hearing of 1 to 1.5 cases a month.
A month?
Not a month. Well, no, more than that, right?
More
Because
than
it's
that.
40.
One a
Yeah,
week.
40 a year. Yeah.
1 a week, you're gonna have people taking vacations, you're
Yeah.
gonna have, so just remind us again, what percentage of applications right now go to be majors?
I know that I'd have to go back into our annual report and dig it up. 15.
10 or 15 is the number that comes to my mind.
Of how many
It's
applications?
about 400
400.
applications and 40 become majors. 30 to 50 in any given year. So, okay, it's 10:30. I think it's time for a break. And Jim McCullough's time was up anyway. So let's recess.